Hello, everyone. Thanks for joining us today. We have a marathon afternoon of CE and/or CLE webinars. I give people a minute or two to trickle in. How many of these presentations have you given on FinCEN's so far, Vince?
You know, this is probably going to be my 5th or 6th one, and I got several more to do in the next couple of weeks. But it's a very, it's a very timely subject. A lot of people are curious about it. There's not a lot recently that's been put out by FinCEN's, so it's something everybody's very curious about.
Sure. And I don't want to spoil your presentation. How much more information are we waiting for FinCEN to roll out before?
Well, you know, probably the big one, and I'll talk about it during the presentation, is the form itself. You know, we're now in under 75 days to the go live date, and we still don't have a form. We don't have a online submission form to play with and to get accustomed to. And I'd say of all the different things that FinCEN could provide at this point that would help, that would be certainly my #1 wish at this point.
Sure. Well, something that was interesting to me is the trial runs that happened earlier this year. I might have been talking with Brent about some of the success that they had actually catching the intended targets with these regulations.
Yeah, under the GTOs, that's right. That was a big part of their justification for this.
Sure. Well, we're a couple minutes after 1 o'clock, and why don't we get started, Vince? What do you say?
Hope you know. Let's do it.
Here. So, hello everyone. We have 3 webinars today. The overall title is Managing Risk, Compliance and Opportunity in Real Estate Transactions. As I said, we have 3 one-hour presentations. There will be a 15-minute break in between each presentation to give you a chance to do what you need to do. And then we have several states approved for CE and/or CLE credit. If you have questions, we'll make time at the end of each presentation to get those answered. So use the chat or the questions box, and we'll make sure that we get your question answered either at the end of this presentation or we'll circle back offline. At the conclusion of total webinar, there will be a survey for you to fill out, and then there will also be poll questions. There will be 2 poll questions during our presentation, 2 during the next presentation, and 3 in the final presentation. So make sure you answer those. Those will be at the 15-minute marks, the 15 minutes, 30 minutes, and then the last one, both of those plus the 45-minute mark. So another note, it's important, please make sure that you are logged into the computer that you registered on. If you are in a group watching on one screen in a conference room, please log into the email that you registered as, because if you're not registered under that email, I cannot verify that you attended the webinar. So having said all of that, our first presenter today is Vincent Danzy. He is Security Title's Vice President of Operations, and he's going to explain FinCEN's soon-to-be residential real estate rule. Take it away, Vince.
Okie doke. Thank you, Drew. Appreciate that. Hello, everybody. I'm glad that you could make it this afternoon. I'll talk about this residential real estate rule. I'm sure it's something that you all have been hearing for a good while now, and you're hearing more and more about it as the deadline approaches. The go live date approaches, which still at this point is slated to be December 1st of this year, which means that transactions that, and actually I shouldn't even say transactions, transfers that occur on or after that date could be subject to this rule. So you might actually already have transactions in your pipeline where the transfers will end up being reportable after December 1st. And as I was mentioning before we even started this seminar, we're still looking for some guidance from FinCEN, and one of the main things we want to get from them is access to the online portal, or at least the form so that we can gain some familiarity with that. And as you'll see, as I talk about this rule, there are going to be some areas of gray that we're hoping that FinCEN can provide some further elaboration on. And one thing I just want to say at the outset, I encourage people to submit questions. The rule itself is structured and set out in a kind of a circular fashion where certain concepts and definitions kind of circle back to others and to, like, as you'll see as we go over it. But my point is, there's really no right way, I don't think, of going through this rule. I think you can pretty much start anywhere on the circle and eventually find your way around, because everything kind of refers back to itself. What I'm going to do is I'm going to shut off my webcam and I'm going to switch attention just to my presentation, and we will take it from there. Okay. So what is the residential real estate rule? In a nutshell, it's a regulation found in the Federal Register, authorized by the Bank Secrecy Act, implemented by the Financial Crimes Enforcement Network, conceived of as a streamlined form of suspicious activity reporting for financial institutions that are persons involved in real estate closings and settlements. And I will go over what the significance is of each of those defined terms. But one thing to keep in mind throughout this presentation, because I think it will make sense, it will put other things into context, is that what we're actually talking about here in filing this real estate report is an abbreviated form of suspicious activity reporting. Now, FinCEN gets its authority from the Bank Secrecy Act. And the Bank Secrecy Act has been around since the 70s, and over time it has been added to. Why do they call it the Bank Secrecy Act? Well, basically because doing business as a bank oftentimes requires secrecy. And the Bank Secrecy Act is a statute that really kind of pares back some of the ability of banks to remain anonymous and secret in their business transactions, and requires certain disclosures. And over time, the disclosures required of banks primarily have gone from initially a focus on anti-money laundering, and over time, particularly after the events of September 11th, the emphasis has really spread to also trying to report transactions that are suspicious, that while they might not be money laundering per se, they could be transactions that go about financing people and organizations that are involved in illicit conduct. And that's really kind of what underpinned the geographic targeting orders that we've all, that many of us have been subject to for the last 9 years, as those orders have spread out over time. FinCEN is a division of the Treasury Department, much like the Coast Guard started out as a division of the Treasury Department. FinCEN oversees the anti-money laundering and suspicious activity reporting obligations of financial institutions. Now, we are persons that are involved in real estate closings and settlements. And that is actually one of the types of financial institutions that is governed by the Bank Secrecy Act. We, however, have historically been exempted from the full panoply of AML, SAR obligations. And what this is really an abbreviated form of SAR, suspicious activity reporting, that applies to us specifically as title providers. Well, I shouldn't even say it applies to us specifically as title providers. It applies to us as people that are involved in these transactions. And I'll explain that distinction in a short while. Now, if you do nothing else, I would write down the address, the official webpage address of FinCEN for this rule. Very simple to remember. It's www.fincen.gov/RRE. And this is where FinCEN has been dumping all of their official and really not so official guidance, as I'll mention also. Just move on to the next slide here. So, reportable transfers, what are they? Well, in a single sentence, a reportable transfer, as defined in paragraph B of this section, shall be reported to FinCEN by the reporting person identified in paragraph C. Now, it's very simple sentence, but there's a lot to be clarified about it. Now, except as set forth in paragraph B2 of this section, a reportable transfer is a non-finance transfer to a transferee entity or transferee trust of an ownership interest in residential real property. And this is going to be the first example of what is done repeatedly throughout this rule, which is to define things very broadly at first, and then enumerate a number of specific exemptions and exceptions from the rule. And that first example is, well, what are not reportable transfers? A reportable transfer specifically does not include a grant, transfer, or revocation of an easement. It does not include a transfer resulting from the death of an individual, whether pursuant to the terms of a decedent's will or the terms of a trust, the operation of law, or by contractual provision. It does not apply to a transfer incident to divorce or dissolution of marriage or civil union. It does not apply to a transfer to a bankruptcy estate, nor does it apply to a transfer supervised by a court. It also does not apply to a transfer for no consideration made by an individual, either alone or with the individual's spouse, to a trust on which that individual or that individual spouse or both of them are the settlers or grantor's. It also does not apply to a transfer to a qualified intermediary for the purposes of 26 CFR 1.1031. That's your 1031 exchange. And lastly, and this is an example of how the kind of rule doubles back on itself, it does not apply to transfers for which there is no reporting person. And we'll go over how to determine that shortly. What is a non-finance transfer? And this is a concept that is one of the most misunderstood parts of the rule, because there's a natural assumption to look at this like the GTOs, which were all about transfers for a certain threshold amount of consideration. A non-finance transfer, which is what triggers the applicability of the rule, means a transfer that does not involve an extension of credit to all transferees that is secured by the transferred residential real property and extended by a financial institution that has both an obligation to maintain an anti-money laundering program and an obligation to report suspicious transactions under this chapter. Now, those are three simple sentences, I guess, but we can also draw from that a couple other things. One is that it's the absence of financing by a regulated bank that triggers reporting, not the involvement of hard money or other types of financing. For example, let's say ABC LLC is going to be the transferee on a transfer. And ABC LLC gets 90% of its financing from Big Lou, the hard money lender, and 10% from Citibank, NA. Because there's at least some money coming from Citibank, and Citibank is a lender that's required to maintain an AML SAR program, the transaction is exempt. Now, let me distinguish that from the case of where you have ABC LLC is getting a 50% interest in the premises, and XYZ LLC is getting a 50% interest in the premises. ABC LLC is getting their money from Citibank, but XYZ is getting their money from Big Lou. In that case, the transaction is reportable because not all transferees are getting their money from a regulated financial institution. Now, how do you know if something, if a lender has an obligation to maintain an anti-money laundering program or suspicious activity reporting program? Well, one of the easy ways you could look at that is look them up and see if you can find their NMLS number, so that you can see whether or not they are registered as a mortgage lender. And if they are, the regulations that require them to be so registered also require that they maintain these programs. So that's a very easy way of determining that the company that you're dealing with has an obligation to have these programs. Now, I had someone ask recently, well, do we need to get a copy of the lender's AML SAR program? And I think clearly the answer to that is no, you don't, because it's not the presence of the program that exempts the transaction, it's the obligation to have that program. And that you can determine by objective evidence, like whether or not they have a lender number. Residential real property, that's one of the easiest ones to get your hands around. That's real property located in the United States. It includes a structure designed principally from 1 to 4 families, for occupancy by 1 to 4 families, or land that the transferee intends to build such a structure. It includes a condominium unit. It includes a cooperative housing corporation unit. Transferee entity, here's another great example of where they define it initially very broadly and then give you a number of exceptions to the rule. So the term transferee entity means any person other than a transferee trust or an individual, other than as specified in paragraph N10 Romanet 2. So what does a transferee entity not include? Well, it doesn't include a securities reporting issuer. It doesn't include a governmental authority. It doesn't include a bank or a credit union. It doesn't include a depository institution holding company. It doesn't include a money services business, a broker or dealer in securities. It doesn't include a securities exchange or clearing agency or any other Exchange Act registered entity. It also doesn't include an insurance company like Security Title, or any state licensed insurance producer, like I imagine most of this audience. It doesn't include a Commodity Exchange Act registered entity, a public utility. It doesn't include a financial market utility or an investment company. Nor does it include any legal entity which is controlled or wholly owned by any of the entities that I just mentioned. Transferee trust. The term transferee trust means any legal arrangement created when a person, generally known as the grantor or settlor, places assets under the control of a trustee for the benefit of one or more persons, each generally known as a beneficiary, or for a specified purpose, as well as any legal arrangement similar in structure or function to the above, whether formed under the laws of the United States or a foreign jurisdiction. Now, a trust is deemed to be a transferee trust, regardless of whether the residential real property is titled in the name of the trust itself or in the name of the trustee and the trustee's capacity as trustee of the trust. Now, in a state like New York, for example, in order for an express trust to hold title to real property, the proper way to title that property is in the name of the trustee for the trust, and that's really what they're referring to there. Again, out of an initially broad definition, there are some exceptions applied to it. A transferee trust does not include a trust that is a securities reporting issuer. It does not include a trust in which the trustee is a securities reporting issuer. It also does not include a statutory trust or any entity wholly owned by a trust described essentially above. Now, one thing to keep in mind there, and is possibly a little bit confusing unless you've read this 100 times like I have, is that a statutory trust is not, a transfer to a statutory trust is not exempt. It's exempt from the definition of transferee trust, but the nature of a transferee trust means that it is almost certainly going to apply it's almost certainly going to be construed as a transferee entity. Because a statutory trust is essentially, it's a trust that, unlike an express trust, which is really just a relationship, and a statutory trust is actually regarded as a separate entity. And so where you have a statutory trust, it's not that it's exempt, it's just that it's not a trust. It's actually an entity. This can be possibly confusing as that might sound. So reporting person, I mentioned that a couple times, and the reporting person is a very important concept. It's actually one that I expect anyone who's new to the rule is going to probably end up spending the most time thinking about. A reporter, and this is actually a sentence I had quoted earlier in the presentation, but a reporting person basically is the one that is responsible for filing this report. A reportable transfer, as defined in paragraph B of this section, shall be reported to FinCEN by the reporting person identified in paragraph C of this section. Now, the way paragraph C works is that a default reporting person is initially determined by a cascade of roles that are set out in the rule. So, and we're going to go over that cascade in a moment. The person who is topmost in that cascade can enter into an agreement with another person within the cascade to designate that person as the reporting person. And if that happens, that person who's been designated, that becomes the person who's treated as the reporting person. All right. And one of the other things to keep in mind is that the rule uses the word person extensively. And, you know, in the real world, we think about person as a human being. But really, when they're talking about person, they're talking about the entity or person. But they're talking about basically the organization, whatever is responsible for doing the role enumerated in the cascade. So, for example, if ABC Settlement is acting as the title agent, it's ABC Settlement that would be determined to be the reporting person, not necessarily the human being that you're going to end up delegating the task to in your organization. So another thing to keep in mind. The reporting person cascade. So the first person, basically we get off at the first floor we can. The reporting person is the person listed as the closing or settlement agent on the closing or settlement statement for the transfer. If there's no such person, then it's the person that prepares the closing or settlement statement for the transfer. If there's no one in that position, then it's the person that files with the recordation office the deed or other instrument that transfers ownership. And if there's no one in that position, then it's the person that underwrites an owner's title insurance policy for the transferee with respect to the transferred real property. Now, you might be wondering, how could you possibly have someone at position 4 if you don't have someone at position 3? In other words, how could you possibly issue an owner's policy if you're not recording the deed? You know, we didn't write this. This was not written by us, but that's the way it is. But if there's no one in position 1, 2, 3, or 4, then it's the person that disperses the most amount of money in connection with the transfer. And if there's no one in any of those positions, then it's the person that provides an evaluation of the status of title. And if there's no one in any of those positions, then it's the person that prepares the deed or other instrument that transfers ownership in the residential real property. And if there's no one involved in the transaction performing any of these, then there is no reporting person. And if there's no reporting person, then it's not a reportable transfer. Designation agreement. So we just went over how the default reporting person is determined. Now, this is the mechanism to designate someone else within the cascade to be that reporting person. And implicit in that is this person can delegate it downstream of that cascade. All right. So the reporting person described in paragraph C1 may enter into an agreement with any other person described in paragraph C1 to designate such other person as the reporting person with respect to the reportable transfer. The person designated by such agreement shall be treated as the reporting person with respect to the transfer. If the reporting persons decide to use designation agreements, a separate agreement is required for each reportable transfer. That designation agreement has to be in writing, and it must include the date of the agreement, the name and address of the transferor, the name and address of the transferee entity or transferee trust, the information described in paragraph G, which identifies the real property, which is actually very minimal information. It's essentially the street address and the section, block, and lot, and the name and address of the person that's designated through the agreement as the reporting person, and the name and address of all other parties to the agreement. Now, one thing I'd like to mention is that in the months since the rule has been promulgated, FinCEN has elaborated that they don't mean by this requirement to require that you include a 30-page agreement with each one of your transfers. There's nothing to prevent you from, let's say, ABC LLC is the settlement agent and XYZ LLC is the title agent, and ABC wants to always contract out, delegate to the title agent its task of being the reporting person. There's nothing to prevent you from entering into a master agreement with each other, setting out all the fine points of your terms, and then having a more abbreviated agreement that refers to that master agreement and that contains these specific enumerated components. Let's see what my next slide is. Before I get to information report, one thing I want to mention is that FinCEN has, and I've seen recently advertisements from companies that say that they can do the reporting for companies that are involved in these reportable transactions. I just want to draw a distinction there. That's not what this designation agreement is for. This designation agreement is for shifting responsibility within the reporting person cascade. It's not an agreement about, between you and your employee about how they're supposed to be doing the reporting. It's not an agreement between someone in the cascade and some company outside the cascade. Basically, the only way to shift responsibility for doing the reporting is within the cascade and downstream from who is first determined as that default reporting person. So what information needs to be reported? This is really where it gets really exciting. And I'm being, of course, facetious there, but the reporting person shall report the full legal name of the reporting person, the category of reporting person as determined by paragraph C. In other words, you're going to be reporting whether or not you're doing, which of those roles you're doing, and whether or not you're doing them because you've been the designated reporting person downstream of the initial reporting person. You're going to be reporting the street address that is the reporting person's principal place of business in the United States. When it comes to transferee entities, the information you're going to report includes the full legal name, the trade name, the current address of the entity, consisting of the street address, and if the street address is not in the United States, then the primary location in the United States where the entity conducts business, and the tax ID of the transferee entity. For each beneficial owner of the transferee entity, and when it comes to beneficial owners, you're really talking very much about kind of the same people that are captured when we're talking about the GTOs, and also the Corporate Transparency Act, which was recently pared back quite a bit. But same general concepts. You're talking about people that have 25% or more or substantial control. You're reporting their full legal name. You're reporting their date of birth, their complete residential street address. You're reporting their citizenship and their tax ID. Now, I'm sure you're probably picking up on the fact this is very much, this is sensitive, personally identifying information. And one of the things that I think this kind of suggests is that the gathering of this information should probably not be lumped in with other forms of communication among the parties, right? This is not, circulating the questionnaire is not something you want to necessarily do with the title commitment. You don't want to be sharing each other's, dates of birth and social security numbers willy-nilly all over the place as you're clearing title. Now, for a transferee trust, you're reporting the full legal name of the trust, the date of the trust instrument, the date the trust instrument was executed, the tax ID, and whether the transferee trust is revocable or not. For each trustee that's a legal entity, you're reporting its legal name, its trade name, you're reporting its complete current address, you're reporting its tax ID number, and a trustee is considered to be a beneficial owner for the purposes of a transferee trust. For each beneficial owner of the transferee trust, you're disclosing their legal name, their date of birth, their complete residential street address, their citizenship, and their unique identifying number, and in other words, their tax ID, and the category of the beneficial owner. Drew, do we need to take another break for a poll question?
Yes, and we also had a question from a slide or two. I didn't want to mess up your flow. The question was, does that mean an agent cannot use a third-party vendor to complete the reporting on behalf of the agent or the reporting person?
So FinCEN, so that's a very good question, and it's frankly, it's one of these questions that I think is still gray, simply because the rule, the FAQs put out by FinCEN, and FinCEN's fact sheet all limit their guidance to delegation within the reporting person cascade. And the rule itself, and I've read it several times now, the rule itself says that the reporting person determined by paragraph C is the one that must file the report. Now, if you were to go to the website of FinCEN that I gave earlier, which was that /RRE, and this is what's a little frustrating, but there is an alert, and that's what it is. This is how official it is. It's an alert, and if you click on that alert, it will say, "Hey, everybody, keep in mind, the BSA filing system that we put out for you and make available to you is free. If you decide to use a third party to submit your reports, they may charge you something and they might have their own terms." That's as close as FinCEN has gotten to formally acknowledging that other companies can be used to help you prepare this. Now, personally, I think that's probably the direction FinCEN's going to go, but I also think it's important to draw the distinction that I think in no way does that enable you to transfer your responsibility out from under you, outside of the cascade. If you're the settlement agent, you can transfer your responsibility to the title agent or someone else downstream within the cascade. But if you have, Acme Real Estate Reporting LLC wants to do your reporting for you, you're still going to be responsible for making that report. So you need to make sure that whoever you're hiring, either as your employee or as your outside consultant, responde ad superior. You are going to remain liable for that. Just like when I use a tax preparer to do my taxes, at the end of the day, that's my tax return. I might use professionals to help me with it, but at the end of the day, that's my tax return. So that's how I would answer that. So let's march on through this information to report. You're also going to need to report the signing individual. That's the person who's actually going to be signing the transfer document. That might be the LLC member, or manager, or president, or it could even be the LLC's authorized person just for that transaction. In that case, you're providing their full legal name, you're providing their date of birth, their residential street address, their tax ID, a description of the capacity in which they're authorized to act as the signing individual. In other words, whether they're the member, authorized person, what have you, and whether or not the signing individual is acting in the capacity of an agent, employee, or partner. Now, information on individual transfers, information required to be reported on transferors in particular, in general, is much more limited. It's not as much information. For a transferor who's an individual, meaning a natural person, you're reporting their legal name, their date of birth, their residential street address, and their tax ID. Nice and simple. If your transferor is an entity, you're reporting its legal name, its trade name, the legal entity's principal place of business in the United States, and their tax ID, its tax ID. If it's a trust, that's the transferor, you're reporting its legal name, the date of the trust instrument, the tax ID, and for each individual who's a trustee of that trust, you're reporting their legal name, their residential street address, and their tax ID. For each legal entity that is a trustee of the trust, you're reporting its legal name, its trade name, its address within the United States where it has its principal place of business, its tax ID. I think I just skipped one. Okay, good. And as regards the property itself, for each residential real property that's the subject of a reportable transfer, the reporting person must report the street address, the legal description, which can really be something as simple as the section, lot, and block, and the date of the closing. Now, this is kind of where the rule starts looking a little bit more like the GTOs. As regards payments, the reporting person shall report the following information concerning each payment, other than a payment dispersed from an escrow or trust account held by the transferee entity or transferee trust, made on or behalf of the transferee entity or transferee trust, and that information is to include the amount of the payment, the method by which the payment was paid, if the payment was made by a financial institution, then the name of that financial institution and the account number, and the name of the payor on any wire, check, or other type of payment if the payor is not the transferee entity or transferee trust. And the reporting person shall report the total consideration for the transfer. Now, earlier on, I mentioned that whether hard money, quote unquote, is involved in the transaction is not determinative of whether or not the transfer is reportable. It's the absence of that regulated money to all transferees that would trigger the rule. Nevertheless, one of the data points that the rule calls for information on is they want you to report whether the reportable transfer involved credit extended by a person that's not a financial institution with an obligation to maintain an anti-money laundering program and an obligation to report suspicious transactions. So you got that binary yes/no question that we're going to be expecting to see on that real estate. Now, filing procedures. This is one little bit of good news, I guess you could say, in that right now under the GTOs, if you have to file a GTO, I believe the GTOs still have the requirement that it must be filed within 30 days of the closing. When they promulgated this rule, they loosened that up just a little bit. Basically, the report has to be filed by the later of the final day of the month following the month in which the date of closing occurred, or 30 calendar days after the date of closing. Now, if you're paying very close attention, you might notice that they're using words like closing here, which might not always really be applicable. You know, this rule applies to gift transactions. This rule applies where there is no consideration, and as the cascade itself kind of makes clear, it applies in cases where there's no closing statement. I think what they're really talking about here is they're talking about the date of the transfer, right? If you don't have a closing, they're really probably talking about the date of the transfer here as the closing. But mechanically, how does this work? So you have 30 days of the last day of the month following. That is generally going to mean that you have until, let's say you close on, you know, March 15th. That means you'll have until April 30th to file. Where it gets a little unusual is really just in a couple instances when you're closing in late January. If you're closing in late January, if you're closing in January 31st in a non-leap year, the farther date is not actually the date of the last day of the following month, which would be the 28th. It's actually March 2nd, which would be 30 days from January 31st. Other than those unusual situations, it's going to generally be due by the day of last day of the month following the closing, and in all situations where you do file by the last day of the month following the closing, you're going to be timely. So that's a little bit of good news. Now, I went over a whole bunch of information, and some of this information we as title providers are likely to have some good details on, but a lot of it we might not have such great details. For the most part, you know, we usually need less information about a transferee, right? That's an entity than a transferor. You're going to need to rely on statements from others that do have this information. And one of the things the rule makes clear is that the reporting person may rely upon information provided by other persons absent knowledge of facts that would reasonably call into question the reliability of that information. The reporting person may rely on the information provided by the transferee or person representing the transferee or the reportable transfer, absent knowledge that would reasonably call that reliability of information into question. So what this basically means is that the transferee can help you with a whole lot of this. And kind of hearkening back to the discussion that we were talking about the reporting person. You know, in a transaction where there's insurance, there's almost surely going to be a settlement agent involved. And there's almost surely going to be a settlement statement of some variety involved. And if you have knowledge that that's the case, if you know that there is a settlement agent, well then, you know, it becomes very simple. Either that settlement agent has to do the report, or they're going to designate you to do the report. And you have to agree to it. You can't be forced to do it. You have to agree to it. But where I think this also comes into play, this reasonable reliance standard comes into play, is not just in the case of the information that you're reporting, but it also comes into play in determining where you are on the reporting person cascade. So if Joe Smith comes to you and says, here's a deed, would you please report it? I think you need to make some inquiries. You have to find out, you know, is there a settlement statement? Is there a settlement agent? Is there someone upstream from me, the person who's being asked to record this? At our company, we are working on developing some forms to assist our agents in doing this, in making these inquiries, so that they have something in their file that they can rely on that indicates whether or not they are that default reporting person. So I really foresee two different types of agreements developing over time. I see this designation agreement as being used a lot, but then I also see the need for some kind of a declaration by the parties to someone who's downstream from that settlement agent on the cascade that enables that person to determine that they are the proper reporting person. One thing I should mention here also is that Alta, one of the good things that Alta has come out with is they've come out with some very nice questionnaires for helping to compile this information. Drew, should I just keep going on through the rest of this presentation, or do we need to stop for one last poll question?
No, we only have two for this hour.
Okay.
You can continue through. I mean, if you want to go until like 2:03 or something, or if you want to cut it off just before 2 and give 5 minutes for questions.
Okay.
Good thing. So I'll stop talking.
So record keeping requirements, that's another thing to keep in mind. The rule has very sparse record keeping requirements. The only two things you really need to keep is you need a copy of any certification of the information, and you need to keep a copy of the designation agreement itself, if one is used. It doesn't mention this in the rule per se, but the period of time for which you have to keep this is 5 years. You're not going to find that specifically in the rule. Instead, FinCEN is relying on the general requirements that they place on financial institutions, which is to hold this information for 5 years. Now, what this should also suggest to you is, what should you be keeping as your record? I don't know how I would feel about only keeping those two pieces of information. I don't know if I would feel comfortable if in 3 years, FinCEN says, hey, can you tell us why you reported this way? And you say, well, I don't have that information anymore, but I must have done it right or something like that. And then in turn, the possible motivation to keep some of this information on hand also brings into play your other obligations as title providers. Like, for example, in New York, we are required to, we have regulations that dictate and provide parameters for how we store information and how we transfer information. How information is kept in storage and how it is transmitted over the internet and otherwise. And this rule is going to expose your organization to increased risk when it comes to that. And so you need to think about that. You need to think about not just compiling this information and doing that in a confidential way, but you should be thinking about it in terms of a storage way. You don't want to have this information be distributed with your prior policy for clearance matters, right? You don't want to send someone over, here's the prior policy and which includes as an attachment the FinCEN information collection questionnaire. So that's another thing that organizationally we need to keep our eyes on. Penalties. This is probably a good place to kind of start winding up here, but like the storage, like the record keeping requirements, FinCEN also took a somewhat hands-off approach when it comes to penalties, and they've left themselves a lot of flexibility here. They really are just relying on the general background penalty provisions of the Bank Secrecy Act that FinCEN can apply against people that don't obey their regulations. There's nothing specific in the rule that says you're going to be punished in this way if you don't follow the real estate rule. Civil penalties are adjusted periodically for inflation by the Federal Civil Penalties Inflation Adjustment Act, and they can also assess criminal penalties for you as well. And going back to what I was saying before about information and not leaking it improperly, also just keep in mind that because of the exposure the increased exposure that you will have vis-a-vis cybersecurity issues and privacy issues, you also got to think about this from the perspective of, what type of penalties might you incur by improperly sharing this information. Exemptions. Generally, this is kind of a brief one to go over, but exemptions, when you might recall that when I started out this webinar, I mentioned that this is an abbreviated form of suspicious activity reporting. Well, one of the normal rules for suspicious activity reporting is that you don't disclose it to the suspicious person. In this case, that's kind of a moot point. Everybody knows this report is going to be made public. Well, not made public, it's going to be reported. So they provide an exemption from that. Beneficial owners. This is kind of a meaty subject. I suggest you just go ahead and read through this. But again, you're allowed to reasonably rely on the transferee and its representatives in disclosing this, right? They're the ones that are going to have to disclose who are these people, who's the trustee, who are the beneficial owners that own or control the entity. One other concept I just want to mention is that the reporting person cascade I mentioned, the first two Romanettes refer to the closing or settlement agent and the closing or settlement statement. Keep in mind, that is a very broad term as defined under the rule. It means any person. The closing or settlement agent means any person, whether or not acting as agent for the title agent or title company, a licensed attorney, real estate broker, real estate salesman, salesperson who for another or with or without commission fee or other consideration provides closing or settlement services incident to the transfer of residential property. A closing or settlement statement means the statement of receipts and disbursements prepared for the transferee for transfer of residential real property. Now, this is one of those terms, I think it really kind of begs further definition. I don't think this is limited to what we've all thought of as a HUD-1 or closing disclosure. I think this could be possibly applied to the concept of a contract of sale or a land sale contract. As you can see, it's a pretty basic and broad definition. Signing individual, we really went over that. Statutory trust, over that. And that's pretty much my show. If anyone has any questions, I'm happy to try to answer them the best I can.
Great, thanks, Vince. I'll wait for any questions to come in. In the meantime, we're going to be releasing over the next several weeks some series of 6 videos that Vince is a part of. Got a couple questions. Why did that not expand out? Okay, a couple of the questions here.
Well, I see Brent has asked about how does this impact courtesy recordings and accommodation recordings. I think it impacts it quite a bit. From one thing, I think it impacts it a lot when it comes to cost, right? If you're a company that has been used to literally doing something as an accommodation or for close to an accommodation, recording a deed and you charge $25 or whatever to record a deed, and you're not issuing title insurance, this rule really can greatly increase the amount of time and effort that's required for you to do that courtesy recording. Because if there's no settlement agent, we saw in the reporting person cascade that number 3 is the person that's recording that deed. So if you have to spend a couple hours doing this FinCEN reporting, that's something to really consider and take into account when you agree to take those deeds on.
The next question is, you might have answered it. Is there a form available for the report required to be e-filed with FinCEN?
Is there a form available? No, there's no form available yet. You can look at the rule itself to see the data, like I just went over, and you can also get a copy of this presentation in PDF form, and you'll see the information that's required. But That's one of the things we're really hoping FinCEN gets around to doing. We understand, I've heard rumors that it's been held up internally, that they had something, but there's some kind of controversy about releasing it at this time. But no, we don't have a sandbox to play in yet.
Yes, latest I heard too. So the next question is, if there is a transaction in which the seller is providing financing, is that a reportable transaction?
Well, keep in mind, this doesn't, whether there's any financing or any consideration at all doesn't really determine whether or not the rule initially applies. The presence of regulated money can exempt an otherwise reportable transaction. So yes, if seller financing, if I'm the sole member of ABC LLC and I'm buying my property from I'm sorry, I'm buying my property from Joe Public, and Joe Public is taking back a mortgage by ABC LLC, seller financing. That will be a reportable transaction, reportable transfer.
Great. Two more. If I prepare a deed to transfer a rental house to an LLC owned by the owners of the property, do I need to report? No consideration, just want limited liability.
Sorry, could you repeat the beginning part of that question again?
If I prepare a deed to transfer a rental house to an LLC that is owned by the owners of the property, do I need to report?
Okay, so there's two questions there. The rental house, the significance of it being a rental house has to do with whether or not you are transferring a property that's fit for occupancy by 1 to 4 families. So if your rental house is a 4-unit property, then it's going to be subject to the transaction. The other part of that question seemed to hint on the ownership of the LLC that's taking title. And so a transfer from me, Vincent, let's say I own Blackacre and I want to transfer that property into Vincent LLC. That transfer is reportable. If, however, I transferred the property from Vincent to Vincent as trustee for the Vincent Revocable Trust, that's exempt.
Great. And then the final question is, what about a deed into a revocable trust for estate planning purposes?
Well, again, so you would have to go back. You would have to go back to the definition of a reportable transfer, and the exception there, the exception from a reportable transfer is limited. It's a transfer for no consideration from me or my wife to me and or my wife as trustee for the trust that I'm the settlor of. If that's your fact pattern, then yeah, it should be exempt. But if that's not your fact pattern, if it's some other type of trust or some other type of arrangement, then it's not going to be exempt. It's going to be reportable.
Great. Well, Vince, thank you. Cut myself off halfway through the sentence, but Vince is involved, as well as Dorian Strothman, a member of our underwriting council, in a soon-to-be video series. We're going to cover 6 parts of this new real estate rule. Where's my Word document here? What is a reportable transaction? Penalties for noncompliance, reporting person designation agreement, info to collect from buyer and the seller, record keeping, MPI, and then the last video will be how to report. So keep an eye out for that. We'll be releasing the first video soon. Thanks everybody, and we'll be back here about 10 minutes. Vince, thanks again.
Thank you. And if anyone has any questions, feel free to send me an email offline, or I'm happy to answer. Thank you.
Awesome. Thanks everybody.